The best of Money Matters. The Big Story.
Welcome to The Big Story. I'm Hongbin Jeong. Now, the government had announced amendments to the Road Traffic Act that remove mandatory minimum sentences for some dangerous driving offences. Now, the changes take effect from today, June 12th. It gives courts greater discretion in sentencing, particularly for first-time offenders, and are part of a broader effort to strike a better balance between deterrence and proportionality. At the same time, authorities have signaled that enforcement will remain firm with increased penalties for speeding and a wider review of traffic laws underway. So what exactly has changed, and how might these amendments affect the way dangerous driving cases are prosecuted and sentenced going forward? Well, joining us today to share more is Muhammad Hasif, who's the Associate Director of AW Law. Hi, Hasif. Welcome to the show.
Hi.
Thank you so much for joining me. Well, Hasif, the removal of mandatory minimum sentences for some dangerous driving offenses kicked in today. In this context, what are considered dangerous driving offenses?
So Section 64 of the Road Traffic Act defines dangerous driving as the driver driving a motor vehicle recklessly or at a speed or in a manner that's dangerous to the public when considering 1, the nature, 2, condition, and 3, the use of the road, as well as the volume of traffic or what is reasonable act of driving for that particular road. Now, we must also consider that this dangerous driving is only in relation to acts that are defined in Section 64 of the Road Traffic Act, so there's no such thing as there are not multiple dangerous driving offences. However, there is a related kind of driving offences that exist under Section 65, which is driving without due care and consideration for other road users. The reason that we as the law firm consider this to be related is that they refer to offences where there is a victim or damage done by the driver as a result of the driver's actions, which is considered less than what's expected of a driver of the road.
Okay. So do these changes today impact how a case is charged or sentenced?
So the changes that kick in June 12, in the Straits Times article, it pertains to majority of the more impactful changes of the mandatory minimum sentence. I think to start off with, the Parliament has not passed an act that removes jail time. There is still jail time for dangerous driving that ends up in the victim being grievously hurt or death for the victim. What the changes refer to is that in the old Road Traffic Act regime, there was a minimum sentence that's being imposed for those offences. For example, where one is charged with grievous hurt, then there's a mandatory minimum of 2 years. For death, it is not less than a certain amount. So in the current regime, this mandatory minimum is being removed from the provisions. However, if someone were to be charged with dangerous driving that caused death is not more than 8 years, and for someone of grievous hurt is not exceeding 5 years.
Well, looking at the amendment in deeper analysis here, one major change is the removal of the mandatory minimum jail sentences and disqualification periods for first-time offenders. Yes. So, yes. The removal of mandatory minimum sentences for the first-time traffic offenders comes in a bid to prevent them from being overly punished. But why now? Are there any specific past cases or legal outcomes that you think played a role in prompting these amendments?
Okay, so in the past, what was defined in the Road Traffic Act was just grievous hurt, and there was a list of what is counted as grievous hurt, which took reference from Section 320 of the Penal Code. So then the question becomes, what is considered grievous hurt and what's considered hurt? Now, why there's a difference and why that difference would be relevant to someone is that when it comes to just hurt, that person does not immediately get a jail sentence. So that's the first part. The first part in trying to remove this is because of the gap in between grievous hurt and hurt. Now, secondly, there's also the issue that for Parliament, it was stated by Senior Minister Faisal that mandatory minimum is not a norm. So removing these mandatory minimums calibrates the offences into what is considered normal for sentencing for the public.
Okay.
There's also the issue of when you talk about blame. Senior Minister Faisal also quoted a hypothetical where a driver who's a first-time offender, he beat the red turning arrow signal and collided with an oncoming motorcyclist. They were speeding. So then the question becomes, if that motorcyclist was not speeding, then this would not have happened. But because the motorcyclist was the victim and then suffered what would be considered as grievous hurt, that taxi driver now faces in mandatory minimum of 2 years in the old regime, right? So in the new regime, that doesn't happen.
Oh, makes sense. Well, then how does removing mandatory minimum sentences for first-time traffic offenders help ensure that the punishment better matches the individual circumstances of each case?
I think when we look at the different, for road traffic offences, because within the dangerous driving provisions is classified between grievous hurt, and death because of the type of harm that's given to the person. Removing the mandatory minimum allows the court to have more discretion when sentencing somebody by taking into account other factors, for example, whether the visibility on the road was affected that day, whether the dangerous driving is as egregious in that particular circumstances. When you give the court more discretion by removing the mandatory minimum, this allows the court to better calibrate the sentences between certain cases, for example, where someone is less culpable or less blame-worthy for a certain traffic offence or traffic offence. The court can impose a lesser jail time as compared to someone who's more egregious. The traffic offence in a heavier sentence will be then imposed. Removing the mandatory minimum widens that range for the court to be able to impose such sentences.
Well, for repeat offenders here, the mandatory minimum sentence has been lowered, but the maximum penalties, such as 15 years jail for causing death, remains unchanged. Why do you think lawmakers chose not to adjust the maximum penalties?
So to reiterate again, the new legislation or the new amendments to the Road Traffic Act makes changes only to the mandatory minimum sentences that can be imposed. So this widens the range of offences that the court can impose, but the maximum penalties was not decreased or changed. I think this, and quoting Senior Minister Faisal, it's about showing that the Parliament's the intent is to allow the court to impose a heavier sentence on more egregious offenders in terms of these acts, allowing the court to be more proportionate and calibrate the deterrence for less egregious offenders.
Well, prosecutors are now given the option to proceed with a lesser hurt charge even when grievous hurt has occurred, and judges have more discretion overall. So, Hasif, what advantages does this flexibility offer in terms of achieving fair outcomes, especially if there are even more complex cases?
So again, going back to the issue of proportionality, there was a case in 2024 in the High Court where the court dealt with the role of the prosecutor in traffic cases, because the prosecutors have a job to choose between dangerous driving, whether it's hurt, grievous hurt, or death. Now, when answering the question, the court ruled that the prosecutor in cases previously, the prosecutor does not have the discretion to choose between hurt or grievous hurt, which means that even a person with low culpability in dangerous driving cases, but when grievous hurt was somehow the victim suffered grievous hurt, they would then be facing an imprisonment of the mandatory minimum in the previous regime. Now, Senior Minister Faisal again raised the hypothetical where dangerous driving was found, but the victim was only suffered a fractured finger, which would, in layman's terms, would be a minor injury. But under the legal rule or the legal definition of what would be considered as grievous hurt, the person would then be faced a minimum sentence that is imposed in the previous regime. Now, allowing the prosecutors to now choose between a lesser hurt charge or grievous hurt would allow the prosecutors to then, again, similar to the role of the judge in sentencing, more flexibility and more discretion when looking at the case as a whole, when looking at culpability as well as the harm done to the person, and here more specifically harm to the victim, whether the victim actually faced hurt or grievous hurt. Looking at a whole host of factors, for example, how many days hospitalization that the person had was given, whether there were complex surgeries done as a result of the injuries, whether there was permanence of the injuries. All these factors can be taken into account when charging and would allow further discretion and more proportionality when dealing with traffic offences.
But could this lead to inconsistencies or public concern about whether justice is being adequately served?
When we look at the changes to the law, there is still some ambiguity. There would be some ambiguity when the court first sentenced the first few cases that occur right after enacting the amendments. But we feel that the positive impact of an increase in proportionality would outweigh any initial ambiguity and any inconsistency throughout and moving forward. So just to highlight another thing, again, at the end of the day, the court sentences the offender in this case So even if, depending on grievous hurt or hurt, the court still has the discretion for hurt from always from a fine to a jail sentence, whereas for a grievous hurt, a jail sentence that is not more than 8 years.
Well, annual statistics released by the traffic police back in February 21st showed a 5-year high in the number of people killed or injured in incidents across 2024. Could removing mandatory minimums weaken deterrence and inadvertently affect road safety?
Again, just to reiterate this, the changes currently does not reduce the maximum sentence. It merely removes the mandatory minimum that is imposable in each offence. So it does not weaken the deterrence factor, as it does not take away the court's ability to impose sentences in each case. In essence, now, the more aggravating the offence, the court is still empowered, as before, to impose a heavier sentence, obviously to the maximum that is allowable under the section.
Well, in Parliament, Senior Minister of State for Home Affairs Faisal Ibrahim clarified that these changes do not signal leniency, but rather a recalibration between deterrence and proportionality. What does the Senior Minister of State for Home Affairs Faisal Ibrahim mean to recalibrate deterrence and proportionality in these changes? Do you see a balance between those two playing out in new amendments?
Okay, so as highlighted before, the removal of the mandatory minimum would allow the court greater discretion when sentencing in each case, and this would increase proportionality. Now, previously, when the amendments were enacted in 2019, mandatory minimum sentences provisions signaled a greater deterrence. The recalibration here is to remove the mandatory minimum and allow the court more proportionality to sentence in each case. We at MICOM and AW Law do see the balance of proportionality and deterrence, especially when now the legislation grants the court greater discretion when sentencing in each specific cases and considering all the factors that go into each specific case. Now, however, we also highlight that there may still be a gap when considering the legislation in dangerous driving in a vacuum, because when you look at the sentencing provisions for dangerous driving that ends up in hurt versus dangerous driving that ends up in grievous hurt. In hurt, the court is able to sentence the offender to a fine or a jail sentence, whereas in the grievous hurt, it starts off with an imposition of a jail sentence. Notwithstanding, we're of the opinion that the balance then is also balanced, holistically when the prosecutor discretion is granted to prosecutors to choose to be able to exercise their prosecutorial discretion to choose between hurt and grievous hurt. When considering all the harm factors that are suffered by the victim, for example, permanence, the nature and the extent of the injury, as well as what were the medical interventions taken by the medical institutions when treating the victim.
Right. Well, the removal of mandatory minimum sentences comes after the announcement of increases in the penalties for speeding offences, and authorities are said to be reviewing other laws and policies to promote a culture of responsible driving and ensure sufficient penalties for offenders. So, Hasif, before we let you go here, what other adjustments to law and policies can we expect?
So, when we look at the enactment of the amendments to the Road Traffic Act, there were other amendments that were laid out in the new Road Traffic Act. For example, the Parliament enacted provisions for more effective prosecutions of offences as well as the disposal of seized properties. Number one, the Parliament has enacted certain provisions that certain summonses can be sent to the offenders via email if it was consented by parties, which would allow more effective prosecution and, instead of the past that we received the same via post, it would be a more effective way of prosecuting offences. Secondly, when we look at certain vehicles that were seized by the government previously, there was a 1-month period before that particular vehicle can be claimed by the owners and the drivers. Whereas now there is a new provision in the Traffic Act which allows owners to be able to claim their vehicle within a collection period. Thank you. Have a nice day.
Thank you. That was Muhammad Hasif, Associate Director at AW Law, LLC. This has been The Big Story with me, Hongbin Jeong.
To listen to more great interviews, download our podcasts at audio.sg or download the audio app. That's AWEDIO, audio at the App Store and Google Play.